Wow, 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 do we have such juicy information today about the Delphi murders. We're going to give you the full context, the full analysis, catch you up to speed, tell you everything that's going on, frame it, and we're going to do it quickly and simply so everyone can understand and be able to catch you up to speed and explain to you the seriousness of exactly what is going on here. Some crazy, crazy stuff going on in this trial. And so to just jump into a little bit of the background so we can just set the stage, set the backdrop before we jump into the analysis of what's really going on legally in this case, let's just give you some basic information. So we've got Abby Williams and Libby German, who were two teenagers who were tragically murdered. They were going through a park and they were murdered, and in a very strange way. And this happened about 5 years ago. The police arrested a suspect, the defendant in this case, whose name is Rick Allen. So Richard Allen and getting ready for trial with his two attorneys. The two attorneys that were appointed by the Public Defender's Office were two attorneys by the name of Andrew Baldwin and Brad Rozzi. Now, who are these attorneys? Are these newbies? Are these guys that are just new to the block? Well, Andrew Baldwin is one of only 4 Indiana attorneys certified as a criminal trial specialist by the National Board of Trial Advocacy. Certainly somebody who knows his way around criminal trials. He has nearly 30 years of a criminal trial experience handling hundreds of jury trials and representing numerous defendants charged with murder. Attorney Baldwin has never been disciplined or suspended. So this is somebody with a very, very solid track record, very ethical guy, was never disciplined, was never reprimanded, suspended, or anything. Who is Brad Rozzi? Well, Brad Rozzi has over 20 years of criminal trial experience, handling thousands of cases, including 8 murder cases. So he's handled a lot of criminal cases, not so many murder cases, 8 murder cases, but he certainly also knows his way around the block. Also, Attorney Rozzi has never been disciplined or suspended. So these are two very experienced attorneys, what it seems like in the criminal trial world. Now, what happens? Well, we have on November 29th, 2022, certain information and the charging information and the probable cause affidavit in Richard Allen's case became available to the public. So this is, again, November 29th, 2022. So in response to that, the attorneys here, the attorney Baldwin and Rozzi, the Richard Allen's defense attorneys, they issued a press release. And in the press release, they responded to the allegations that were contained in those affidavits and the charging information, and they reasserted Rick's innocence. Now, this was November 29th. A few days later, the court entered a gag order saying that now no one is allowed to talk to the press. No one's allowed to make any extrajudicial statements, anything out of court. You're not allowed to do. No press releases, no nothing. The court entered this gag order. Now, the court also entered a protective order prohibiting the parties from divulging or granting access to discovery material. So any material that you have as the attorney, any discovery material, pictures, filings, pleadings, indexes, anything that has to do with the case, that has to do with what can be considered discovery, which is basically everything in the case, you are not allowed to divulge or grant access to that either to anybody. Okay, so that's what happened. Now, in December 21st, 2022, so this is about a month, a little bit less than a month after this, we have Rick's counsel, who was Andrew Baldwin, inadvertently emailed a summary log of the evidence on a flash drive, which he received during discovery. So he emailed this information, this log, the summary of the log of the evidence. Again, nothing substantial, nothing substantive in this email, but it nevertheless was a log. It was basically a log of the different evidence, pieces of evidence that they have in this case. So it was a mistake that he sent this email out. This is, again, December 21st, 2022. So let's remember again, we had November 29th, 2022 was when the charging information became public. Then we have Baldwin and Rozzi issuing a press release. And then we have this gag order, which was entered after that. And then after the gag order, there was this mistaken email that went out from Andrew Baldwin to somebody else by mistake. And it contained a log of the evidence. Again, nothing substantial, nothing substantive, but it did technically violate the gag order. Okay, so that's one thing. Now we also have the fact that Richard Allen, is being held at Westville Correctional Facility, which is a maximum security prison. Maximum security prison is questionable about whether this person who has not been convicted of anything yet, Richard Allen, again, remember, he's presumed innocent, he is being held at this maximum security prison. So that in itself is a question in this case, whether he should be there at all. But he's there and he's complaining about the inhumane and unequal treatment that he's receiving at this place. So what they did is that they filed a tort claim, meaning his public defenders, these attorneys, Rozzi and Baldwin, they filed a tort claim notice, meaning a notice that they're going to be filing a tort claim against the prison to preserve Rick's rights to obtain private counsel after the criminal case is over, to be able to file a civil lawsuit against the prison. So that's what happened there. Now we have some more interesting information. Okay, now in August of 2023, so this is almost a year after those events that we just discussed, that mistaken email was in December 21st, 2022. Now we have August 2023. Listen to what happens. A former employee of Attorney Baldwin's office, the defense attorney, the person's name was Mitchell Westerman. He stopped by Baldwin's office to visit. So he stopped by to visit the office. While he was there, Westerman slipped into a conference room where he found crime scene photos. And by his own admission, meaning this is Mitchell Westerman, he admitted that he did this, he secretly photographed some of the discovery material and disseminated it. So he got this law firm who's preparing for this trial, which is coming up. This is in August 2023. So they've got a special war room, a conference room, which is dedicated, what seems like it's dedicated to this case. They've got all these pictures out. They've got the file out, probably a lot of papers around, a lot of documents out. And this former employee stops by the office, maybe just to chat with everybody, say, hey, how's everybody doing? And sneaks into this room, sees what's going on, takes some pictures of the crime scene photos, and then he disseminated it to the public because he understands how national this case is. So he goes and he wants to get some fame for himself, I guess, and he disseminates these pictures. Now, the attorneys were not aware that he did this until later. When they did become aware, when the defense attorneys for Richard Allen, Baldwin, and Rozzi became aware of this, what did they do? They immediately disclosed the matter in an email to the court and to the state and to the prosecutor's office. Then they let them know on October 6th, 2023. Now, that was October 6th. On October 9th, 2023, this guy, Mitchell Westerman, told his former employers, Attorney Baldwin, about what he did, his inappropriate, if not criminal conduct, that he secretly photographed these discovery items. Now, of course, the dissemination of this information is obviously against the order also that the judge put into effect. Again, this is not the attorneys doing it. They didn't have any control over this. I mean, technically, they could have not allowed him into the office. Maybe they could have locked the door, but they didn't do it themselves. Somebody came in and took pictures and disseminated information. Again, technically against the order, but that's what happened. So immediately when they found out about this, they immediately let everybody know. They let the court know. And now we have on October 9th, this individual, Mr. Westerman, Mitchell Westerman, comes clean. He tells his former employee about what he did. And immediately the attorneys go and tell everybody what happened. Now, they had a telephone conference with the court that day to discuss the matter. So they had a telephone conference. This is on October 9th, 2023. They had a telephone conference between the defense attorneys, the prosecutor, the state, and the judge. And in that conversation, the state mentioned that, maybe this actually rises to disqualification of these attorneys. Now, of course, the state wants these attorneys to be disqualified. Sounds like it, that they want them to be disqualified. It seems like they're very experienced, know what they're doing, and they're about to get ready for a trial. And apparently it seems like the state wants more time or whatever it is. So the state mentioned the issue, and again, I'm just going into their minds a little bit, but on the phone call, they did mention the issue of disqualifying the counsel, disqualifying these defense attorneys from representing Richard Allen. Now, they let Richard know about this, and they let the defense attorneys let the defendant, Richard Allen, know about this. And Richard immediately said that he still wants these attorneys to represent him, believing that their representation was in his best interests. And he put this information in a letter, and that letter was filed with the court on October 12th, 2023. Now, after receiving Rick's letter, Richard Allen's letter, the court notified the parties that it was scheduling a hearing on October 19th, 2023 to address other matters which have recently arisen. So this is the court letting the attorneys know that she is scheduling, this is the judge saying that she's scheduling a hearing on October 19th, 2023. And she also ordered that Rick's counsel, the defense attorneys in this case, Baldwin and Razi, cease work on Mr. Allen's case until we meet on the 19th. So stop working. We're not going to work on the case at all for the next few days. You're going to come into a hearing on October 19th, 2023, and we're going to discuss these other matters which have recently arisen, essentially suggesting that we're going to discuss this at that hearing. Now, there was an appearance in the chambers. And this is when it all gets interesting. Okay? Now, this is October 19th, 2023. Now, this is not a court. This is not a judge that allowed the cameras or the cameras into the courtroom during any of these proceedings before this. Now, all of a sudden, on October 19th, I think that's the case. By the way, correct me if I'm wrong, but I believe that that's the case, that she did not allow any cameras into the courtroom until this hearing on October 19th, 2023. And if I'm wrong, I apologize. Please correct me if you know that she did allow the cameras in before. But it seems from the filings that this is the specific hearing that she allowed cameras in. Now, this hearing on October 19th, 2023, she opened the courtroom to the media. So, what happens? What happens is that there is, before, now you have a court open, right? You have the courtroom open, you have the courtroom filled, you have the media there. Everyone's waiting to hear what this hearing is about and what the judge is going to do, what they're going to argue about, what does this have to do with the case. Everyone's waiting there. Now, in the meantime, there is a meeting in the chambers, in the court chambers, meaning in the judge's chambers before, not an open court. This is in the judge's chambers, just the attorneys are present and a court reporter. And during that, there's a whole transcript about what occurred during that meeting in the chambers. And essentially what happened was they discussed a lot of the different pending motions that were going on, and then they brought the judge brought up the topic of these, what seemed to be violations of the gag order. We got the press conference, you've got this filing about Richard Allen getting his treatment at the jail, and then you also have this major leak, this dissemination of these crime scene photos that were able to be taken in the defense attorney's office and disseminated by this person. So this is what the court tells the attorneys, the defense attorneys, Mr. Razi and Mr. Baldwin. This is what the judge tells them in chambers. Now, this was all written down, so this is how we know it's from the transcript. And this is what she says. Here we go. This is what I intend to say in open court. This is the judge talking. This is what she's telling the attorneys. Listen to me. I wrote this out. I wrote out what I'm about to tell you, and this is what I intend on reading in open court with all the cameras there, with the whole courtroom full. This is the statement that I intend to read. Here we go. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing on November 22nd of last year. Remember, this is November 22nd, 2022. Mr. McClelland filed Mr. McClelland is one of the prosecutors. Mr. McClelland filed a motion for a gag order, and we were in chambers, and you assured me, gentlemen, we don't want the media in our lives. We will not try this case in the media. So this was November 22nd, that there was another meeting with the judge in chambers where it seems that both attorneys said, we do not want to start leaking things out to the media. We're not trying to do this case, we're not trying this case in the media. This is not something that we want to do. And then what happens? Continues the judge. And less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. So in that press release, she has some issues with what the defense attorney revealed. Now remember, Remember what we said earlier. This was November 22nd. The first leak that came out was actually by the prosecutor, the state, and that was November 29th. That was also after. The judge does not seem to have an issue with what the state put out. At least she doesn't talk about it in the statement. She's only focusing on the defense attorney's actions in this meeting in the chambers and in this statement. I don't know, and she continues, I don't know, I think you knew or should have known those were potentially violative of Rule 3.6 of the Rules of Professional Responsibility. But it is that press release that prompted me to issue the order December 2nd, granting the gag order until further hearing. So she's saying that it's because of your press release, you defense attorneys, you who told me that you don't want to go to the media with this, and then you go to the media and you issue this statement, which I think may violate the rules of professional responsibility. And like I always say in some of my other videos, whenever you threaten an attorney that they violated the rules of professional responsibility, it's really getting personal. This is not an issue that you're taking with his tactics, his approach, his analysis, his analytical ability. You are taking issue with his morals and his ethics. So it's right away, it's a dagger to the heart when a judge mentions something about you violating the rules of professional responsibility. So she does mention that. And she says that that's the reason that she granted eventually the gag orders, because of this press release. Now, does it have anything to do with the fact that the state released the charging information and the affidavits for probable cause? Well, she doesn't mention it. Well, why not? Okay, well, that's just a question you can have in the back of your mind. But it didn't seem that she had an issue with it. She only had an issue with what the defense released in their press release. Now, continues the judge in her statement that she intends to read in open court. April 18th of this year, you filed a notice of tort claim against the Department of Correction. You stated in that notice that it was your intent to pursue our client's claims against you, meaning our client's claims against the Department of Corrections. The full amount of damages sought on behalf of my client is unknown. I don't know how you could do that in representing Mr. Allen in a criminal matter and then launch off into a civil matter. I think that's inappropriate. So the judge is saying, you're representing Mr. Allen in a criminal matter, and now you writing a letter or a complaint or a notice to preserve your complaint against the jail, that's inappropriate because that's a civil claim, not a criminal claim. Now, personally, I don't understand what the problem with that is. I don't know why, as a criminal attorney, you can't write a letter to preserve your client's tort or civil claim that they may have, and you're not necessarily going to represent them in that civil claim. They may be getting some other private attorney to represent them in that civil claim. You are just doing your job as an attorney to let to preserve any claim that your client may have. So I don't really understand so much why this is inappropriate, but this judge feels that it is inappropriate. All right, let's continue. May of this year, we were notified by the state of the Brandon Woodhouse arrest and the subsequent discovery of your work product, and I think it was an outline that you created for yourselves with the discovery. She's referring to the email. It was pretty detailed. I don't know if that's the right word. That apparently happened in December of last year, and that was not revealed to anybody, not shared with this court. It wasn't shared with you, although apparently you guys knew about what was going on. So then Mr. Woodhouse gets arrested, and here we are. Now, here is where the judge starts laying the hammer onto the defense attorneys. Grossly negligent to email that to the wrong Brad. So this mistake that you made, that you sent this email to the wrong person, the judge is calling that gross negligence, which we're going to jump into in a minute to explain to you what exactly the difference between negligence and gross negligence is. But she's saying that this is grossly negligent to email the wrong Brad. Your pleadings on the safekeeping order contain inaccuracies and falsehoods. Okay, now she's saying that your pleadings contain inaccuracies and falsehoods. That was proven in the hearing we conducted in June. The evidence presented by the state clearly demonstrated the falsity of your claims, and that was very troubling to me. And then, the last couple of weeks that we've been dealing with, the state provided you discovery that has been severely compromised. We now have an ongoing investigation. I'm not going to call it a criminal investigation. She's referring to the investigation into these pictures that were leaked. I don't know what it is, but it's clearly being investigated by the state of Indiana. Everyone involved has sought counsel, including you, Mr. Baldwin. You've had an attorney enter a written appearance this morning. So Mr. Baldwin himself, one of the defense attorneys, actually got counsel himself. He retained counsel himself on behalf of that issue. I don't want to get into the investigation, candidly. And then she continues like this. He included the fact that you left materials all over your conference room table accessible to anyone, and this is a friend of yours who apparently you have consulted with on this case. So again, it's up to you if you wish to pursue that. I'm looking at the totality of the circumstances. And here she goes. Here she's about to drop the hammer. You know, when I look at a suppression, the case law requires me to look at the totality of the circumstances, and that's what I'm doing. And it pains me to say this, but the totality of these circumstances demonstrate gross negligence and incompetence on the part of the defense team. I am unsatisfied with your representation of Mr. Allen. I am gravely concerned about his rights to have competent, non-negligent representation. He currently doesn't have that right now, because what you have demonstrated is negligence and incompetence. Now, I am sharing my thoughts with you privately. I don't want to say this in open court. I would encourage you to talk privately about what you wish to do. I don't want this coming out. It is not where we need to be with this case, but I will. So, essentially, the judge is telling them, I've got all this media here. I invited the media. We've got open court. I'm going to read this to everybody in the courtroom, and I'm going to be saying how I find that you're grossly negligent and you're incompetent and you cannot represent Mr. Allen. So you basically have a choice. Either we do that, I go and read this in open court with all the media, and this will be shown around the entire world, and that's the end of your careers, essentially. Or you can withdraw on your own, and then I won't have to do this. I won't tell anybody why you're withdrawing. You can just withdraw on your own. So that's exactly what Mr. Razi says. He says, I mean, obviously, reading the tea leaves here, what you're giving us a chance to do is bow out gracefully, if you will, if that's the right term. And that essentially is what happened. Now, let's discuss for a second if this is gross negligence. Let's talk about what happened. Now, again, like I said, the fact that they preserved his right to have a civil case filed against the corrections, against the prison, is, to me, I don't see any problem with that in the slightest. Now, the fact that you sent an email to the wrong Brad, and the fact that you allowed this person, this former employee of yours, to come into your office and now snoop around and take some pictures of that, does that constitute gross negligence? So gross negligence essentially has the same definition or similar definitions in almost all jurisdictions, but I did pull the one from Indiana, and this is what I found the definition of gross negligence to be in Indiana. Gross negligence is generally defined as a conscious, voluntary act or omission in reckless disregard of the consequences to another party. That's what gross negligence is. What's negligence? Negligence is basically not acting in due care. You have to act with due care, how normal people would act for the safety of yourself and others. That's, if you don't act with normal, the way you normally would act for the safety of others, that's negligence. Gross negligence is a conscious, voluntary act, reckless disregard of the consequences. Was this reckless disregard? Did you go to the public library to prepare this case and leave all these pictures over the public library? That would be gross negligence. Did you open up a sign by your office saying anybody who wants can come in today and take a free drink and snacks, and over the snacks table you left over these pictures of the Delphi? That would be gross negligence. What happened here, the fact that a former employee came into the office and you weren't careful enough to make sure that that door was locked so the former employee can't do something and take some pictures and disseminate it, that does not rise, in my opinion. That does not rise at all to gross negligence. Perhaps it's a case for negligence, perhaps, and I'm not 100% certain that it is, but you can make a case that maybe it's negligence. But gross negligence, incompetence, I personally don't buy it. I don't think that that's gross negligence at all. Yet, this judge disagrees with me. This judge says that it is. So now what happened here? Well, what happened here is that there was a writ of mandamus that was filed with the Supreme Court of Indiana. There is a writ of mandamus, which is basically what happened here is now, again, let's just set the stage. So we got these two attorneys, Razi and Baldwin, who now said, okay, we're going to have to withdraw. What do you think they did? Of course, they're not going to risk getting embarrassed in front of the entire national legal world and national world by letting this judge in front of all these cameras say how she feels that they're grossly negligent and incompetent. So they said, okay, we're just going to withdraw, even though Richard still wanted them to be part of the case. Now here's where it gets even better. So the court now appoints 2 new attorneys, right? 2 new attorneys to take over this case. Now, these attorneys that were representing the case before, Baldwin and Razi, before they were representing Richard Allen by being public defenders. So you get paid a certain amount. Now they offered, because Richard Allen really wants them on the case. They've been working on this case together for a year. They've been preparing it. They're supposed to go to trial in January 2024. And he really wants them as part of the case. So they go, when these new attorneys file their appearance and start taking over the case, these other 2 attorneys, Baldwin and Razi, file an appearance saying that we're going to appear pro bono, which means that they're going to appear for free. Richard Allen really wants us on the case. We understand, the judge, you don't want us to be the public defender's office. Fine. You can appoint 2 other public defenders on this case and to make sure that we're not grossly negligent. But we want to appear and help Richard Allen with this case pro bono, for free. We're going to do this for free. All these hours of work, we're going to do for free now. And the judge still did not allow them to appear. Let me see if I can get the exact quote here. I have grave concerns. This is the judge after these Razi and Baldwin want to appear on behalf of Richard Allen for free. And Richard Allen's there in the courtroom. So this is the judge talking to Richard Allen. I have grave concerns, Mr. Allen, about their representation of you, their previous findings by this court of their gross negligence. Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, because I know what you want. You've indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns that I've had with the gross negligence that I have found. They withdrew rather than be found grossly negligent and be removed. I can't do it, sir. I just can't. I cannot allow that. So she does not allow them to even appear pro bono, for free, on behalf of Richard Allen in this case. And now, because these new attorneys show up, and they're completely brand new to this case, they can't try the case by January 2024. So therefore, the judge grants an extension of the date to occur October 2024. So now the trial is just pushed off from January 2024 till October 2024. Now we know that a defendant has a right to a speedy trial. And that was one of the arguments that the attorney Razi and Baldwin would be making. So now what happens here? What happens here is that there's a writ of mandamus that is filed. The writ of mandamus is when you ask a higher court to tell the lower court, or to order the lower court what to do. So here you've got these 2 attorneys, Razi and Baldwin. They filed their writ of mandamus. Well, they didn't do it by themselves, but they did on behalf of other attorneys, did on behalf of them, with the Supreme Court of Indiana, so that they should tell this lower court, this judge, to allow these attorneys, Razi and Baldwin, to represent Richard Allen in this case. And that's what they ask. And they also ask that they remove the judge, because the judge obviously has some very strong bias against these attorneys. She thinks that they're grossly negligent and incompetent. So that's not fair to have her preside over this trial. So they're asking for 2 things. They ask the Supreme Court of Indiana to now tell this lower court and this judge, you're off the case. And these 2 attorneys are back on the case, because this is absolutely ridiculous. Now, do I believe what happened in this chambers is absolutely ridiculous? I think it certainly borders on it. This is not due process in the slightest. You just call some attorneys back there and say, well, either you do this or I'm gonna threaten you and embarrass you. That's not due process. What are the claims here? You feel that they're grossly negligent? Let's have a hearing about it. Let's have witnesses. Let's have exhibits. That's what due process is, just to threaten some attorneys, to throw them off the case because you as a judge feel from hearsay evidence that they were grossly negligent. This is not right. And this can really infringe on Richard Allen's Sixth Amendment rights. Right to counsel by their choosing. Richard Allen wants these attorneys to represent him, And the judge is not allowing these attorneys to represent him. Now, what also is interesting here, it's unbelievable, but what also is interesting here is that when they filed this writ of mandamus with the Supreme Court of Indiana, so that they should tell the lower court to stop with this monkey business, they filed a motion to get the transcript from the conversation that happened in chambers. This one that I read to you, about what the court said what the judge said that she's going to read into the record. So they asked the court reporter who was there, who wrote everything down, who has this transcript. They wanted to order the transcript, and the court, or the court reporter, probably through the court, didn't want to provide it. They didn't want to provide it. So the Supreme Court of Indiana actually had to order them, the lower court, to produce this transcript. And that's what happened. So now we have this transcript, and that's how I was able to read it to you. And now the Supreme Court is reading all this, and I assure you, I can't assure you, but I imagine that the Supreme Court is appalled. This is not, you can ask a first-year law student this, and they're going to say, this just reeks. This is not due process. So this doesn't seem like due process, and I think that this is just, it's just mind-blowing. It's just unbelievable that this is going on in such a big case like this. So this is what's going on right now. They filed this writ of mandamus, and now we're just waiting to see what the Michigan Supreme Court, the Indiana Supreme Court is going to do with this case. And I don't know. I would find it hard to believe that the Indiana Supreme Court is not going to rectify some of this. Probably they're going to reinstate these counsel as Richard Allen's defense attorneys, and whether they let this judge allow this judge to stay on the case, I don't know. I really don't know. I don't know if they're going to let this judge stay on this case. I can't guess about that, but I mean, I guess they can go either way. But I wouldn't be surprised at all if they tell the judge that she can't sit on this case either, and they may have some choice words for her as well. But again, this is all speculation. I don't want to speculate about what the Indiana Supreme Court is going to do. But that is my take. That's what's going on in the Delphi murder case. This is unbelievable stuff. If you haven't yet, please subscribe, like the video so we can continue growing. That is it for today. See you next time.